We have many wonderful speakers lined up for our panels this afternoon. Before that, though, I have the pleasure of introducing a distinguished guest to deliver the opening remarks. Judge William H. Pryor, Jr. is a judge on the United States Circuit Court of Appeals for the 11th Circuit. A graduate of the Tulane University School of Law, Judge Pryor has sat on the court since 2004, when he was nominated by President George W. Bush. Before that, he was Alabama's Attorney General. In his time on the 11th Circuit, Judge Pryor has written many opinions that have won him plaudits from conservatives, including from the current occupant of the Oval Office. It is our pleasure to have him with us today, and I hope you'll join me in welcoming him.
Good afternoon. I would like to take a moment first to pay tribute to William F. Buckley, Jr., and to commend the Buckley program for maintaining his legacy of reasoned debate of political and social issues. I became an admirer of Mr. Buckley during my freshman year in college. Soon afterward, I began subscribing to the magazine he founded, National Review, and I have remained a subscriber to this day. In the 1980s, I watched Mr. Buckley skewer his debating adversaries on his television show Firing Line on Sundays as faithfully as I watched the Alabama Crimson Tide play football on Saturdays. For me, if Ronald Reagan was the political leader of the conservative movement, then William F. Buckley, Jr. was its intellectual leader. One of the highlights of my legal career involved Mr. Buckley and came during my judicial confirmation battle in 2003. My nomination, if you didn't know, generated controversy. The minority party engaged in a filibuster of my nomination. The president later gave me a recess appointment, and my Senate confirmation came 2 years after my nomination. After my confirmation hearing, Mr. Buckley wrote in his syndicated column that I was, quote, the most refreshing thing to happen to Washington since William Faulkner said the reason he wouldn't be going to President Kennedy's Nobel Prize winner party at the White House was that Washington was a long way to go for dinner. Mr. Buckley apparently liked the candor of my testimony before the Senate Judiciary Committee, and his words of approval were more than enough for me to be satisfied with that testimony. So I was delighted to accept an invitation from the Buckley program to travel all the way to New Haven to deliver the opening address at your annual conference today, even though I must return to Alabama tonight so I can attend the LSU versus Alabama game tomorrow. Roll Tide. This 7th annual conference is entitled The Constitution and the Courts, and those words are in the correct order. What sets the American political system apart from its British predecessor is that we have a written constitution that establishes and reigns supreme over all the branches of our government. As Thomas Paine observed in Common Sense, in absolute governments, the king is law, but in America, the law is king. Our Constitution is our law and our king. I want to address 3 related issues. I want to speak today first about our Constitution and what makes it great, and then about the duty of our courts to uphold it. And finally, I want to explain why Americans have a duty to criticize the courts when we fail in our duty. We have a structural constitution. Our Constitution creates a federal republic of enumerated and separated powers with remaining authority reserved to separate state sovereigns and the people. Although the Bill of Rights and the judicial interpretation of its provisions attract the lion's share of both law review articles and media commentary, the structural restraints of the separation of powers and federalism are what actually preserve individual liberty from the inevitable overreach of government. In the Federalist, number 51, James Madison put it this way: in the compound Republic of America, the power surrendered by the people is first divided between two distinct governments, and then the portion allotted to each subdivided among distinct and separate departments. Hence, a double security arises to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself. The late Justice Antonin Scalia reminded us that it is a mistake to think that the Bill of Rights is the defining or even the most important feature of American democracy. Virtually all of the countries of the world today have bills of rights. You would not feel your freedom secure in most of them. Justice Scalia explained that because the real constitutions of those countries, the provisions that establish the institutions of government, do not prevent the centralization of power in one man or one party. They enable the guarantees to be ignored. In the words of Professor Michael Paulson, our Constitution established separate, independent branches, exercising some separate and some shared powers, and each armed with some power to check and balance the others so that no government branch or official would become a tyrant. Indeed, almost 1 year ago today, faith in the importance of a divided and limited government appeared to gain some traction in unexpected quarters of academia. Perhaps there's still hope for the future of our structural constitution. Of course, the practical difficulty with the lofty sentiment that the law is king is that the law is not self-executing. A king can build castles and lead armies. Our Constitution sits quietly behind bulletproof glass in the National Archives. If the rule of law is to apply to every official must interpret and respect the law. And when conflicts arise, the Constitution tasks the judiciary with providing a forum for applying the supreme law to public officials in actual cases or controversies with citizens. This important obligation to uphold the Constitution implicates a second critical duty. Before a court can apply the law to a particular case, it must first determine what the law is. As Chief Justice John Marshall explained in Marbury v. Madison, it is emphatically the province and duty of the judicial department to say what the law is, because those who apply the rule to particular cases must of necessity expound and interpret that rule. This second obligation to determine what the law is where judges occasionally get into all kinds of trouble. Judges may sometimes allow their personal preferences to color their interpretations of the law, and judges may forget that they are but one of the three branches of our government. Indeed, liberals and conservatives alike can agree that even the Supreme Court occasionally gets it wrong, sometimes horribly so. Dean Erwin Chemerinsky wrote a few years ago that the court has frequently failed throughout American history at its most important task, at its most important moments. And the consequences of those errors can be catastrophic. Consider the decision of the Supreme Court in 1857 in Dred Scott v. Sanford, where the court invoked the oxymoron of substantive due process to rule that the Constitution barred the federal government from regulating slavery in federal territories. This monstrous decision, of course, led to our bloody Civil War and was cured only by a later constitutional amendment. And the judiciary can just as easily err when it interprets the Constitution too narrowly. In 1896, the Supreme Court upheld state-sanctioned segregation in Plessy versus Ferguson, based on the curious reasoning that although, quote, the object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, it could not have been intended to abolish distinctions based upon color, end quote. The consequences of this decision to gut the 14th Amendment were again severe. although history would eventually vindicate the prediction in Justice John Harlan's dissenting opinion that Plessy will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. The Supreme Court did not overrule Plessy until 1954 in Brown versus Board of Education. And early on, the Supreme Court did not confine its error to issues of race. For in 1873, the court ruled in Bradwell versus Illinois that the 14th Amendment permitted states to bar women from the practice of law, even though the amendment protects all persons from state-sponsored denials of equal protection. The twin errors of the Supreme Court striking down constitutional laws and upholding unconstitutional laws are not unique to the 19th century. In 1927, in the notorious decision Buck versus Bell, the Supreme Court found no constitutional problem with a Virginia law that permitted, in the words of the court, the sterilization of mental defectives. And in 1944, the Supreme Court approved the internment of Japanese Americans during World War II. Throughout the early 20th century, the court erroneously ruled that the First Amendment permitted the federal government to outlaw both criticism of the First World War and the political speech of communists and socialists in Debs versus United States, Schenck versus United States, and Abrams versus United States. Although more recent decisions make clear that the Supreme Court now better respects the robust guarantee of the freedom of speech under the First Amendment, other terrible decisions, like Buck versus Bell, have never been overruled by the court. Of course, all peoples and institutions are fallible. Fortunately, the court is able to reconsider its precedents and overrule its wrong decisions. But bad decisions, like Plessy, can have long lifespans. Although the judiciary plays a critical role in preserving the rule of law and securing constitutional freedoms, the judiciary is also more than capable of getting the law terribly wrong. The good news is that knowing when the judiciary errs does not require a judicial commission or even a law degree. Americans, regardless of whether they hold public office or have legal training, are often capable of determining when judges have misread a clear statute or butchered the Constitution. And Americans are entitled, even obligated, to criticize those errors. Criticism of erroneous judicial rulings honors our constitutional tradition. Criticism reminds judges that the Constitution, not any particular judicial interpretation of it, is the supreme law of the land. Criticism reminds judges that the people are sovereign. Criticism maintains accountability for judges who are otherwise insulated from political and economic pressures. Fair criticism poses no threat to judicial independence. The Constitution confers life tenure on federal judges and provides that their compensation shall not be diminished during their continuance in office. Judges also enjoy absolute immunity for their official actions, and Congress has exercised the impeachment power only rarely in cases of personal instead of partisan misconduct. Indeed, I think it is fair to say that a federal judge enjoys more job security than any other public official not named Coach Nick Saban, and even he has to hold press conferences and answer to the media. So instead of treating harsh criticisms, whether in law reviews, newspapers, or even tweets, as existential threats to judicial independence, we should acknowledge that criticisms are instead part of a long history of keeping the judiciary faithful to the Constitution. Criticism is an antidote to the two main impulses that lead judges to stray from the Constitution. The first of these is the temptation to substitute one's personal preferences for the text of the Constitution, an inclination that Justice Scalia frequently acknowledged. In United States versus Virginia, the Supreme Court ruled that the 14th Amendment required the Virginia Military Institute to admit women, but Justice Scalia disagreed. His dissenting opinion lambasted, quote, this most illiberal court, which has embarked on a course of inscribing one after another of the current preferences of the society, and in some cases, only the counter-majoritarian preferences of the society's law-trained elite into our basic law. And in Atkins versus Virginia, the court held that the Eighth Amendment prohibited the execution of the mentally retarded. But Justice Scalia again dissented. He argued that seldom has an opinion of this court rested so obviously upon nothing but the personal views of its members. In an era where the Supreme Court views the Constitution as demanding evolving standards of decency, standards that in many cases may happen to align with the preferences of the judge or justice who is writing the opinion, we face the constant threat that the rule of law will be replaced by the rule of lawyers. Public criticism is a necessary counterweight to this particular threat. Americans must remind judges that we judges are mere mortals, and that we may not always share the values and experiences of the majority of Americans. As Justice Clarence Thomas pointed out in his concurring opinion in Glossop versus Gross, a recent case that reaffirmed the constitutionality of the death penalty, quote, there is a reason the choice between life and death within legal limits is left to the jurors and judges who sit through a trial and not to the legal elites or law students. He observed that local citizens are, quote, collectively better suited to make the moral judgment between life and death than are the products of contemporary American law schools. Of course, judges are not populist windsocks beholden to the sudden passions of the people, but judges certainly need frequent reminders that we are not the arbiters of right and wrong. We take an oath instead to do equal right to the poor and the rich and to uphold the law. The second impulse that can lead the judiciary astray is a misguided view of the institutional role of the judiciary. More specifically, a court, including the Supreme Court, might hesitate to enforce the Constitution or faithfully interpret a statute, not because the justices personally approve of a particular result, but because the court believes that it must improve the work of the political branches. For example, in 1892, the Supreme Court ruled in Holy Trinity Church versus United States that a federal law that broadly prohibited assisting or encouraging the importation or migration of any alien to perform labor or service of any kind did not bar a church from hiring an English pastor. The court reasoned that the spirit of the law, if not the letter, established that Congress did not intend to exclude clergymen and other skilled workers from the United States, but instead meant, quote, simply to stay the influx of this cheap, unskilled labor. No matter what the text of the federal law said, the court thought it knew better what Congress intended. 2 years ago, the Supreme Court determined in Yates versus United States that a statute that prohibits knowingly altering or destroying any tangible object for the purpose of preventing or impairing the government's lawful authority to take such property into its custody or control did not apply to a fisherman who had thrown undersized fish overboard after a government inspector had ordered the fisherman to preserve the fish until the ship returned to port. The notion that a fish is not a tangible object is puzzling to me, but I suppose that not all of the justices had the benefit of growing up on the Gulf Coast of Alabama. Regardless, the court in Yates decided that it could deduce a better meaning from an already clear statute. I will leave it to your good judgment and further consideration to identify other cases where the court attempted to bail out Congress by fixing a poorly crafted law. Public criticism is a necessary response when the judiciary invades the territory of the political branches. The American people should remind judges that legislators and voters are perfectly capable of fixing broken laws. And sometimes It may even be necessary to inform judges that the law in question is actually working or not working as designed. When the political branches have decided what the law is, our Constitution permits no judicial revision. Our history is filled with prominent Americans who have criticized judicial decisions. One of the sharpest rebukes came in 1832 when President Andrew Jackson vetoed legislation that would have renewed the charter of the Bank of the United States. In 1819, the Supreme Court had ruled that the bank was constitutional, but President Jackson disagreed. In his veto message, President Jackson declared that all federal officers have the duty to decide upon the constitutionality of any bill or resolution that may be presented to him for passage or approval. So when the president exercised his independent authority to veto legislation renewing the charter of the bank, the decision of the Supreme Court on the constitutionality of the bank had, in President Jackson's words, only such influence as the force of its reasoning may deserve. Decades later, after the Supreme Court decided Dred Scott, President Abraham Lincoln harshly criticized the opinion for transforming the United States into, quote, one universal slave nation. But he never advocated outright defiance, although President Lincoln urged the Supreme Court to overrule Dred Scott and denied that the decision should control future parallel cases. He conceded that constitutional decisions must be binding in any case on the parties to the suit. As with all political speech, the best criticisms rebuke sloppy reasoning and erroneous decisions without undermining the rule of law that is inherent to our Constitution. President Lincoln struck the right balance in his criticism of Dred Scott. Although he promised to oppose that decision as a political rule and proposed so resisting it as to have it reversed if we can and a new judicial rule established upon this subject, Lincoln rejected the notion that when Dred Scott has been decided to be a slave by the court, we as a mob will decide him to be free. Of course, not all criticisms will be so nuanced. Following the decision in Dred Scott, Senator Charles Sumner of Massachusetts, in a phrase that perhaps coincidentally contains fewer than 140 characters, declared that Chief Justice Roger Taney had, quote, degraded the judiciary of the country and had degraded the age. But even these harsh words acknowledge the authority of the judiciary to render binding decisions. A balance between acid commentary and respect for the rule of law is essential. As American citizens and as future leaders of our republic, you owe a duty to point out when the judiciary misinterprets the Constitution or any other law. But in doing so, be careful to explain why the judiciary got it wrong instead of disrespecting the authority of the judiciary. That kind of constructive criticism, exposing errors while acknowledging the constitutional authority of the courts, expresses the highest respect for the fact that we have a government of laws and not of men. Thank you.